Good afternoon. Before I start my presentation, I would like to thank NADPOP and PHCERT for inviting me to the first Data Privacy and Cybersecurity Professional Summit. As much as I would have loved to be with you today, unfortunately, I am not able to do so. However, I hope that my discussion would provide some useful insights as you continue your privacy practice in your respective organizations. Today, I will be sharing some of the things that I have learned in the past 5 years almost that I have been doing privacy work. A lot of my work, actually, as a privacy lawyer, consists of contract reviews. So, I would like to share with you today some of the things that I think we can apply in order to better manage our vendor risks through contract negotiations and contract reviews. Okay, let's proceed. So as we all know, privacy violations are bad for business. So it's not just bad for the brand, but it's also bad for the pocket. So when I say bad for the brand, what does this mean? Alam naman natin that there have been so many corporations that have been cited in recent years for privacy violations. A lot of the breaches are now being reported primarily because there are also regulations that require notification of the affected data subjects as well as the regulatory authorities whenever breaches happen. So who could forget, 'di ba, about the COMELEC breach, which at the time that it happened was one of the more significant privacy breaches that have been recorded. Of course, through the passage of time, yung record ng COMELEC has already been surpassed. I'm sure that you will agree with me that the data breach that happened in COMELEC has actually colored the way that we perceive the legitimacy of our elections. And it is not just the government brand that suffers when there are privacy breaches. This brand damage is actually more palpable in the private sector. So one of the, I think, bigger examples of this is Facebook. While the 2016 Cambridge Analytica scandal is not exactly a data breach as we know it to be under the Data Privacy Act, still, it is seen as a significant privacy violation. And we all know that ever since Cambridge Analytica has been reported, Facebook has also been facing rough seas, not only in brand perception, but also with respect to more actions of the regulators. So actions of the regulators we have seen are from the FTC in the United States, as well as in different countries. So there have been actions in Ireland, there have been legislative inquiries even in the United Kingdom. And then, as I said earlier, privacy violations are also bad for the pocket. Privacy violations can give rise to complaints for damages. The National Privacy Commission, for instance, has already issued the administrative fines. And we see that the amounts that the NPC has the power to levy is nothing to sneeze at. Similar to the GDPR's penalty framework, the National Privacy Commission also has a penalty framework that is based on the annual income of the company. So it might be obvious, and it's actually obvious, that you should, as personal information controllers, care about vendor risk. But let us just go through the statutory provisions that also demonstrate the importance of caring about vendor risk. So let's take a look at what the Data Privacy Act provides. Section 3, which is under the definition of terms, paragraph H, defines a personal information controller as a person or organization who controls the collection, holding, processing, or use of personal information. So as you can see here, I have underlined controls, and this is the most important word in this definition. The PIC controls the purposes as well as everything that happens to the personal data. Then, of course, it is understandable that any consequence arising from any personal data processing activity would also be the accountability of the personal information controller. This accountability is made more definite by Section 21 of the Data Privacy Act, which provides for the principle of accountability. So Section 21 states that each personal information controller is responsible for personal information under its control or custody. In fact, when we say control, this means that responsibility or that accountability follows the personal data even when it is transferred by the controller to another entity, such as a third party who will do the processing, whether domestically or internationally, of the personal data. So whenever we engage vendors, whether as personal information processors or when we transfer personal data to vendors in their capacity as also a personal information controller, Section 21 of the Data Privacy Act says that the disclosing controller remains accountable or responsible for the personal information that it transferred. Okay, finally, we go to Section 14 of the Data Privacy Act, which specifically provides for the subcontract of personal information. This provision states that a personal information controller may subcontract the processing of personal information. However, personal information controller shall be responsible for ensuring that the proper safeguards are in place. So when we take a look at how we can ensure that the proper safeguards are in place whenever we engage a vendor and transfer personal data to these vendors. One of the more effective avenues to ensure the proper safeguards are in place is through contract negotiations. And as I said earlier, I will be sharing with you the things that I have learned in my 5 years of practice as a privacy attorney. There is also an NPC advisory opinion that further demonstrates how the personal information controller is responsible for vendor risks. In this advisory opinion, the requesting entity requested advice from the National Privacy Commission with respect to contracts where it is forced to engage with vendors, usually internationally, even if these vendors refuse to provide or to include privacy provisions in their contracts. There are instances where there is only one or two vendors that is able to provide the product or service that we want. And in cases where these vendors are located in other jurisdictions, these vendors usually do not welcome the inclusion of privacy provisions based on the Data Privacy Act. Oftentimes, these vendors will insist on the privacy provisions in their own jurisdictions. I have personally experienced dealing with vendors where they insist on having us sign their contracts on a take it or leave it basis, taking into consideration the requirements of the Data Privacy Act, but at the same time, accepting that there are a lot of times where the balance of power is skewed versus personal information controllers that are located in the Philippines. How is a personal information controller supposed to approach a contract negotiation with a vendor that refuses to include privacy provisions based on the DPA in the contract? Here, the NPC stated that at the end of the day, the PIC has control over which entities to engage and contract with. So it is the prerogative of that PIC to continue the contractual relationships. So while the NPC accepts this reality, the NPC still insists that it is up to the personal information controller to determine internally if continuing with the contracts with non-compliant entities is viable for business. So in cases like this, the personal information controller actually needs to weigh the risks versus the benefits. So if the personal information controller in its assessment sees that this very important product or service is something that it cannot do without, then the personal information controller certainly has the prerogative of then the personal information controller certainly has the prerogative of going through with the contract. However, the NPC says that there are attendant risks to this relationship vis-a-vis the requirements of the DPA and the expectations. And for this reason, as the DPA states, the personal information controller will remain accountable. So now that
Okay.
we have the statutory and regulatory basis out of the way, let's proceed to the discussion of tips on how you can manage vendor risk through contract. Complete the PIA before you start contract negotiations. I cannot stress the importance of the PIA as a tool in helping you in your contract review. Oftentimes, the language of the contract does not tell you what happens in the real world. It doesn't tell you how another personal information controller to whom the data is transferred will actually be processing the data and for what purposes. It will also oftentimes not show what exactly a personal information processor will be doing with the data. So it's very important to have the PIA. And if you are the lawyer doing the contract review, I cannot stress enough the importance of actually reading the whole PIA before you even make comments on the contract. The PIA is the most important tool for you to understand what will really happen. This is actually even better than conducting interviews. And why is that? Because a lot of times the facts will change depending on who you talk to. At least with the PIA, we have written documentation that has been prepared and signed off by the proponents, as well as other units within the organization that will be involved in processing the personal information. Also important is the fact that the PIA actually surfaces important problems or privacy risks that may result when the information is processed. Since the privacy risks or these potential problems have already been raised, you now have the opportunity in the contract to address some of these problems. Of course, I know that not all of the privacy risks, not all of the potential problems will be solved by tweaking the contractual provisions alone. But at least you are able to catch and address the ones that you could. Next tip, an important prerequisite before you even enter into contractual negotiations is to find out if the vendor has a privacy management program in place. At the very minimum, you need to make sure that the vendor has an NPC registration. This is especially important for those entities covered by a mandatory registration requirement by the NPC. Third, ensure that the rights and obligations of the parties are clear in the contract. When I say clear, I mean that each of the parties have the same picture of what will happen in the real world when this contract is already implemented. So one example I can think of is responding to data subject access rights. When data subjects exercise their rights under the Data Privacy Act, is it really clear in the contract who should respond to this data subject requests? This is particularly important when there are two personal information controllers that are sharing data with each other. So where does one personal information controller's data processing activity end and the other personal data information controller's data processing activity begin? These need to be mapped out and clear between the parties and as written in any documentation that the parties have. This will ensure that no data subject requests are left unattended. Of course, we all know the perils of ignoring data subject requests, right? If you are not able to respond to a data subject request within 15 days, then that data subject actually already can go to the NPC and file a complaint against your company. Another thing that we need to consider here is that our beloved templates may not actually accurately provide for the rights and obligations of the parties. So this means that each contract and each transaction is reviewed closely on a case-by-case basis. I cannot stress enough the importance of not just copying and pasting the template, because the provisions that you may be putting there may not be applicable to your transaction. Number 4, nail down the SLAs and the vendor's commitment to cooperate. This is actually very, very important in the case of personal data breaches. Of course, we all know that the Data Privacy Act gives us a very tight deadline for mandatory notification of the National Privacy Commission as well as affected data subjects. 72 hours is really not enough time. You have to be sure that you have contractual provisions that specify within what period your vendor should notify you of any personal data breach at their end. You should also have clear contractual provisions that state the turnaround times for your vendor to give you information in case there are follow-ups from the NPC or if there are follow-ups as well from the affected data subjects. Some breach investigations actually take some time. So it's really important that throughout the conduct of the investigation, your vendor does not leave you hanging, and that you can also rely on the cooperation of your vendor when, after you have submitted your breach notification to the NPC actually gives you a follow-up letter ordering you to submit further information as part of their investigations. Can you just imagine the problems you will have if your vendor refused to cooperate after you receive a follow-up letter from the NPC asking for further information about the incident? 5, provide for and clarify audit rights. So I'm sure all of us have a provision in our templates stating that the personal information controller has the right to audit the personal information processor. But, most contractual provisions do not really go beyond that. Your contract should clarify when the controller is able to exercise this right. Moreover, it should be clear between the parties what happens if there are actually audit findings. Is the personal information processor obligated to cure those lapses? And if yes, who pays for these corrections? It is best that these items are already agreed upon between the parties upfront before they even start implementing the contract. Okay, number 6, ensure the training is in place and the training is effective. I've seen a lot of instances where vendors readily sign warranties in the contract stating that they provide regular training for their personnel. But how sure are you that the training that the vendor is providing to its staff is adequate for the purposes of the personal data processing activity for which you are engaging the vendor? So time and time again, I have seen that a commitment from the vendor stating that they will be training their personnel is not enough. It is always best if you could have a way of setting up a mechanism whereby you can see how the training is being conducted. At the very least, you can see the material that is being distributed. For companies, for instance, that have a lot of distributors, it could be a good approach to organize a regular training program where key personnel of all of your vendors are able to attend. Finally, remember to consider privacy and liability provisions. One approach that you could take is to ensure that liability arising from privacy violations be exempt from the liability cap. So why is this important? As you can see, depending on the nature of the personal data processing activity, there can be violations where there would be a lot of affected data subjects. And depending on the seriousness of the breach, your company could end up being liable for millions in actual damages to the affected data subjects. So taking liability for privacy out of the liability cap, it gives you comfort that you can seek reimbursement from your vendor for the full amount of the damages that you paid for any privacy violation caused by your vendor. Finally, I think the most important advice that I can give is do not be afraid to negotiate. There are a lot of instances where contract negotiations can be intimidating, especially if you are negotiating with a vendor that is a multinational corporation. I have been in some successful contractual negotiations when we were able to have tech giants accept the changes that we wanted to their template provisions. So just go ahead and negotiate. Remember, it is your liability that you need to watch out for. And with that, I hope that I have shared important insights with you. Thank you once again. And I hope that you have a productive and enjoyable rest of the conference. Good afternoon.